What I'm going to do is just touch on some of the ethical and legal issues that's associated with accessing data with a focus on biobanks. I'm going to just kind of touch on some of the issues with biobanks and then how it relates to AI, with a particular focus on medical AI, because biobanks have medical data. Okay, so when we're thinking about medical AI, what we need is lots and lots and lots of data. And ideally, you want global data sets because, to offset issues relating to bias. But this data comes from humans. It's going to come from all of us. And all of us have human rights and interests that are impacted with when people and organizations and businesses are trying to access the data. Can you think of any of our rights that are invoked when a company is looking to access your data? Anyone? Yeah, privacy, data protection. Anything else? What about our right to autonomy, our right to decide over what will be done and how our data will be used? Some people, if you think of the empirical work that's done on people's attitudes towards accessing data, everyone has different attitudes. Some people are like, go, take it. Others are like, I don't want Google or a company to have my data. So we all have rights and interests in accessing the data that are impacted. So where do we get the data? Well, biobanks, which is, as you all know, a large collection of samples and data, are one possible way to get the data. They have a lot of baseline data on healthy populations. And increasingly, they can be linked with your medical records. So it's having up-to-date data. That is important when we are developing AI. What's also important is that when we have this data in a biobank, participants will have given consent to their use for certain purposes. So there may be specific consent, generally not what is done. Most commonly, they're kind of on what we call broad consent. A participant has broadly consented to the use of their data for research for certain diseases, or for research generally. We have the UK Biobank as one example. Increasingly, there's a possibility that consent can be dynamic. And I'm going to come back and give the example of our biobank where I work with to talk about that. So what's useful is that we have a biobank or a data bank where people have already said, okay, here you can use my data for certain purposes. So you can go in and get access to that data. They'll also have governance procedures in place that enables the access of that data. Because it's not just consent we need to worry about, but there are, procedures that you need to have in place. You need to ensure that you have sufficient protections in place, security provisions in place to comply with GDPR, but you also may have ethical oversight. So these are all issues that you need to think about when you're accessing the data. So rather than you going, okay, I need to consent, I need to go to the ethics committee, I need to have governance procedures in place, you can go, right, I'll just go and apply to this biobank and get access to that data. So it'll be a much more easier way for you to go about getting data. Now, one particular biobank is the CRIS biobank, where I work with in the north of Italy, in South Tyrol. That's the province where we're in. It's been going on since 2011. And so we have 13,500 participants enrolled. We are just starting CRIS 2, which is our follow-up of about 5,000 participants. And just last year or earlier this year, we completed a project called CRIS 2D, which was completely done over COVID. And we built a portal that allows, and the idea is that the province gave us funding through the European Commission to develop this portal to kind of advertise or promote the biobank so that external researchers can access the resource that we have for projects that are in line with the objectives of the CRIS project. Now, we have adopted what we call a dynamic consent platform. And what dynamic consent generally means is that you use information technology to stay in touch with your participants. And what's good about that is that they can update their consenting preferences. They can update, we can actually reach out to them. So we conducted a study during COVID on a healthy population in Italy at a time when, things were pretty bad there. So it gave us an avenue to actually talk to our participants. Also, all of us under the GDPR have a right to information, and that is a right to know what your data is being used for. And so our dynamic consent platform enables us to give ongoing information about the data use to participants. And when we think about the empirical work that's done in this area on accessing data, people often say, you know, okay, I'm happy for my data to be used, but I want to be told what it's being used for. This platform allows us to do that. And so what our participants did way back in 2011 is that they consented to certain research areas that they were happy for their samples and data to be used for. Anything after that, we need to go back to them. But they can also use this platform to withdraw their consent or change it. You know, for example, they may not want us to share with external researchers, but they're happy for us to use it. This allows us to do all of that. And we have also, yes?
What if somebody dies?
It depends. We've covered that. So from a data protection point of view, GDPR doesn't apply after upon death. However, some people have said that they're happy for their data to be reused. Others have said they would like their data to be anonymized. And that brings in the whole issue of genetic data and the fact that you can't truly anonymize genetic data. Some people have said they'd like to withdraw from that. The issue that we have faced is, how do we know when they die? You know, when you die, your family kind of takes care of the bank. They kind of does it, but you don't think to go and call up the biobank. We are now getting to the stage where we're notified of death because we're at the follow-up stage. So we've gone back and we started recontacting people, and so we're notified of their death. So we go back to the consent, see what they have decided, and withdraw. Actually, a funny little anecdote. We did have a really strange case of someone who died and their son impersonated them to get their samples out. Their consent form had said that they didn't want, that they were happy for us to use it. But when they died, their son pretended they were them because they knew their details, got in touch with us and wanted to get rid of the data. They were totally anti-data sharing something. But we found out that it was an impersonation, but it was a strange one. But yeah, that's what happens. We deal with that at the time of consent. Now, for our governance, we have co-produced it. Italy, the use of genetic data in Italy is very strictly regulated. We're one of the most strict procedures in place in the whole of Europe. But we have kind of co-produced our governance procedures with them. So we are governed by the CRIS consent. We also have ethics committee approval. But we have ongoing discussions and dialogue with the participants all the time. For example, we were developing this data portal, we actually had discussions with not only the participants, but the local political community, the mayors, and also the hospital, because we have actually got a floor, our own space within the hospital. So we're very much integrated into the local healthcare system. We also have a clearly defined access policy, which we just revised and updated in line with this new data portal. And so it's very clear, and we're also in the process of developing SOPs. For example, you know, things like, you know, a checklist to see whether or not data is anonymous or not, because, you know, it's either personal data, which has all the protection of the GDPR, or it's anonymous, which has none. But it's often not very clear if data is, you know, personal or anonymized. So we're developing a lot of SOPs and stuff like that as this kind of robust governance procedure. We're also, as part of the kind of extension of the data portal, we began to think a lot more about engagement with industry, because it's not just a research resource for researchers, but, like, you know, the idea is that it's used for everybody and that we have that. So we're starting to thinking more about the ethical issues that may arise with regard to that. And also, if you want to get access, you go and log onto this data portal and you submit a request in line with our access policy, and then our access committee meets once a month, and we decide on access. We decide on whether or not they are fit in line with our access policy. And so that is, you know, a kind of system that we set up over the past 10 years. It's a dynamic governance system that we're constantly having to adapt and change in accordance with the law. For example, June of last year, we had our Garante, which is the data protection authority in Italy. It issued a terrible opinion, which basically requires specific consent for all research in use and reuse of biological samples and data in Italy. But our governance procedures and the dynamic consent processes allows us to kind of adapt to that. So that is how we've dealt with it. And so biobanks or biobank, for example, could in theory be a good resource to access our data. But the problem is that this is our approach, and we have this fragmented application of the GDPR across member states. So and not only is it a fragmented application across member states, to get access to each biobank, they'll also have their own governance procedures in place, because and you want to have a lot of data. So you might decide, okay, I'm going to apply for Chris data, and then I'll go to UK Biobank as well. They all have their own differences in place, which you are going to have to navigate. And in addition to the legal issues, there is also different ethical rules on the secondary use of data. Italy is quite strict, and it's very, very strict in how you get access to the data for secondary use. You need to have consent. Fine for us who has a dynamic consent platform, and we can go back and chat to our participants, but it's more problematic for other biobanks who don't have that in place. And then at the beginning, like I mentioned, we want to have global data sets. Well, third country access, so any countries outside of the EU or the EEA, which does not have an adequacy decision with the Commission, which basically there's only 11 or 13 countries, I can't recall, outside of the EU where you can share data freely. It's very hard for those countries to get access to our data. And then even when you do get to the point where you can access the data, the whole process on the data transfer agreements and negotiations are quite complex. They can take a lot of time. And while we have quite a nice, clear governance procedure in place, and once the access committee has decided you can get access, actually the DTA working on it can take quite considerable time, which again, all needs to be navigated. So in addition to, you've got the ethical compliance you need to consider, you've got the legal rules of that country. Then you have the rules of each biobank, which are different even in the same country. And then once you finally have access, then you've got the whole negotiation of DTAs. And when you're dealing with different countries, everyone wants disputes to be settled in their country, but that can't always be the case. Now, Europe is very much aware that we have a lot of data and that there's a lot of potential use of this data. Europe is also very aware that and concerned that we're not particularly competitive compared with, in particular, the Asian and the US markets. And one of those reasons is it's over-regulated. In the clinical trials, any of those of you who work with clinical trials, you know what I'm talking about. It's highly, highly regulated. Getting access to data is also very, very challenging and problematic. So Europe wants to fix this and is with a focus on being much more competitive, having better regulations in place, having clearer regulations in place. I'm doing this by having more regulations in place. So it's this kind of access to data is in a very, very, very dynamic space. We all know the GDPR because it's, cookies have been the bane of our life since it came in a few years back. But there's more. We've had the Data Governance Act that's come into place, which is all about getting access to public sector data. And we also have the AI regulation, which was just discussed and passed in Parliament on Wednesday. And that is going to very much impact the life and the regulation of AI. But for the rest of the next 10, 15 minutes, I want to talk about the European health data space, because that's going to change things an awful lot if it works out as they hope it is. Now, there's two main aims of the European health data space. One relates to the primary use of data, one relates to the secondary use of data. And the primary use of data, it's all about enabling patients to access their data across member states for healthcare. So simply put, that means that in theory, if it works as it's meant to, for those of us who move around a lot, your data will go with you. So rather than I'm Irish, I live in Italy, I've also lived in the UK, and I've also lived in Switzerland. And every time I start off a new healthcare system, I have to tell them the same issue, rather than being able just to move the data. They're hoping that the aim is that this will fix it. Now, I'm going to focus on the secondary use of data, because that's important for those of us who want to get access to data for AI. And what the European health data space wants to do is to provide both an infrastructure and a legal framework in place to enable the secondary use of data. And it applies to both personal and non-personal data. So personal data, which is data on all of us, genetic data, medical data, but also non-personal, like anonymous data. So it's applying to both of those, because the GDPR only applies now to personal data. Now, it's not about establishing an EU database of health data. What it just wants to do is to provide one legal framework and one infrastructure in place for all of the member states for anybody who wants to get access to data. Now, what it's going to do is that, subject to certain conditions, and this is quite novel, subject to certain conditions being met, it's going to create an obligation on data holders to share electronic health data with data users for certain purposes. So I'll repeat that again. It lays out certain conditions, a lot of them to relate to data protection and security issues. But if those conditions are met, it's going to put an obligation on data holders to share electronic health data with data users for secondary purposes. And a data holder will be anybody broadly within the health arena who will have data. So your medical records will be included in this. All the data within the CRIS biobank will be included in this. All of this so CRIS as a biobank, we would be a data holder. And a data user will be anyone who's seeking to get access for certain, a data user will be a person or an individual or a business who's seeking to get access to that data. So it's very broadly defined. Now, I think what's important for us is for what purposes and what data is being included. It includes all electronic health data, which there was no getting around, a lot of text on this slide. But here you'll see that there's going to electronic health records, data within population biobanks, so CRIS data, data impacting health. So it's very, very, very widely defined. So all of that data can be accessed, and all of our data will be included on this, because we all have health records. Anybody who signed up, like I'm a participant in a biobank in Ireland, my data will now be included in that. But for what purposes? So we want to access the data for secondary uses. Is it any use that you want? Well, at the moment, there are 8 purposes, and quite a few of them relate to AI. So activities for reasons of public interest in the area of public and occupational health, that will gain access, that could relate to AI. Development and innovation activities for products or services contribution to public health or social security. Providing personalized care. And training, testing, and evaluation of algorithms. You can access data for that purpose. Also scientific research related to health or care sectors. So these are the 8 reasons for which you can, under the proposed, it's only a proposal at the moment, access data for,
Is there a provision, like a plan for what will happen in the step afterwards? What I mean, a researcher will come to the biobank and align with these rules, but then they can come up with the technology and they might sell it to a company and it's going to be...
Really like that question. No. And they're actually, and it's not even that they'll come to our biobank because they're going to change the governance. But no, the focus is on getting access to the data and not access to the technology or the results or products that flow from this data. And there's a work that I've been doing with colleagues of mine, and we have a paper with the European Journal of Human Genetics. And this is one of the critiques we have, is that it's very much focuses on freeing up data. But just because you've got access, we give access, and it'll be our data, remember. And just because we're giving access to the data, it doesn't mean we have access to technology. And the COVID was a great example of that. You know, we had this data sharing experiment. One of the reasons we often hear why we had the quick vaccines is because there was access to that data. But once we had the vaccines and therapies developed, kind of national and economic interest took over. And, you know, we were all saw, you know, countries that didn't have access. For example, healthcare workers in Nigeria didn't have access to the first vaccine when I was on my second dose, and I was just living at home because I'm a healthcare worker. So no is the answer, and there's no benefit sharing plan associated with that. It is also difficult to do, but yeah, it doesn't. It's just focusing on getting access. So they're the 8 purposes for which you can get access to data. It's in draft format. It came out last year. The Commission published it May last year, I think it was. They are hopeful to get it done by next year. Bit ambitious, but it is coming down the line. So that is how it's set up. This is what it broadly wants to do. So how do you go about getting access to the data? Well, as I mentioned already, if you want to get access to ORCRIS data, you got to come to us. But if you want to get access to a lot of data, you have to go to everybody, which is very frustrating for you, with navigating all these rules. And even within Italy, you know, we're all interpreting the laws ourselves. So you might find that we all, like, you know, you're talking about 5 or 6 or 7 different interpretations. That's just in one country. And if you're going to cross the whole member state, you know, you can see why people are frustrated and, you know, just don't bother. Well, the European Health Data Space is not only going to change how we access data, but how you, or the type of data we can access, but also how you do it. So what we'll have is we'll have a data holder. And we'll use the example of my biobank, or biobank Chris. So we'll be a data holder. And what we're going to have to do is just give a description of the data set available to the Health Data Access Board. I've just abbreviated there. This is a new entity which is going to be created in each member state. And what will happen is that a data user will make an application to a health data access body. And so you can say, okay, I want data from the Chris biobank, I want data from an Austrian biobank, I want data from another one in Napoli, for example. So you're just going to make an application to the health data access body. The Health Data Access Body will be in each member state and will have a data catalogue of all the available data sets in that country available. It is then you will apply for the access to the data, and they will check your application, make sure that you comply with the rules under the European Health Data Space, very much focus on data protection issues, check that it is for what you fall within one of the purposes, the 8 purposes that are broadly defined. And once they're happy that you have met all the rules, they will issue a data permit. And within 2 months, the data holder must make the data available. 4 months in exceptional cases, which I think is actually quite, ambitious, considering how much time-consuming it can. So the data user, the only responsibility that they have is to ensure that you use the data in line with the permit. Now, if you're making an application for a certain purpose, the data user can only use that data for that purpose. But I think for anybody who's been involved in trying to access data, it's very much going to streamline the process. It's going to make things a lot easier for you. And so the question is, do you think this is good news? Anybody got a thought? Is it good news? You all, do you think? It could be. Why could it be? You get a lot of data. We need data to do stuff. Do you see any downsides? Yeah. What?
It's what my concern is what I said before, like what happens with this data.
Yeah.
And who controls what happens. And there is also the matter of once somebody has access to this data and then they do not comply with even with the initial permit, what happens then? Who is going to be like the stakes are very high and I don't know what's going to happen next.
Yeah, so if they don't, it's the Health Data Access Board is a body which is going to have responsibility for compliance, and we still then have the supervisory authorities for the GDPR, who will also have responsibilities for ensuring compliance with data protection issues. How they're going to work together, we don't know. But the kind of downstream access isn't guaranteed. And I think this is a really valid point, and one that is not kind of thought about or discussed. Well, I think it's thought about, but I think it's kind of ignored. Oh, 5 minutes. Ignored, which is problematic. Any other issues you see? Yeah.
So I think there are actually a lot of power asymmetries, it seems.
Yes.
Because we are, on one hand, allowing private entities developing AI very easy access to the data. But then, like, my question is, can also these entities be considered data holders?
Yeah,
for instance?
yeah,
So
they are. So they are. And what's interesting is that we often hear pharmaceutical companies saying we need access to data, we need data, we need data, but they're very, very slow to give us access to, like researchers, to the data. It's an obligation on everybody. But if you don't know the data exists, how can you go and access this? Now, they are responsible for making the data catalog available, but is that really going to get around secrecy issues? I'm not really sure. But to answer your question, yes, everybody, everybody's considered. They will both be considered, both private and public. But I think your point in power symmetries is really, really valid, because it's very pro-business, it's very pro-commercials. It's responding to a lot of the commercial calls for making data available. And I just like to say, I am in favor of making data available, subject to conditions. You had a point as well.
I was thinking about other data that can be linked to
Mhm.
secondary
Yeah.
data, so that can be used to identify
Yeah.
either groups of people or maybe
Mhm.
persons.
Yeah.
as well.
Yeah, and there's no consideration for discrimination, to making sure the implication of discrimination and stigmatization, which is one of the criteria for our biobanks, is we have in making the data available, or our samples available, discrimination and stigmatization are both taken into consideration. What about the fact that all of our, so you go to the doctor, I don't think everybody here has been to a doctor at some point, and you have given a lot of information. Some of it maybe you never wanted anybody else to see. Do you have issues with the fact that you have potentially no say? Because did you hear me talk about the role of the individual? Actually, in a second, the role of the individual. Because under the current, the original draft, there was no right for us to opt out of our data being used. So if we had, Google or we have Sanofi or Pfizer wanting access to our data, we have no control over it going out. Now, the European Parliament has proposed to change that and have an opt-out, so that we have the possibility to opt out. But which kind of speaks to that a little bit. But some people want to opt in only. They don't want it to be assumed that our data is going out. Some people want to opt in subject to, their own personal criteria. Yeah.
And then there's also the individual responsibility of the doctor, because each doctor has responsibility towards the patient. So me as a doctor, yes, I have to comply with the rules of the system, but when somebody is sharing with me information, I have
Yeah.
responsibility towards them, and I don't think this is also covered. Like that, I might choose not to be involved as a practitioner, not as a patient as well.
Yeah, you've no choice. Like it's all about getting the data available. That's actually a pretty good point. Any other concerns with this? Yeah.
Ciara, is the registration to the catalog an obligation for
Yeah.
biobanks?
And it's not just for biobanks. It's anybody whose data, anybody who has electronic health records.
Okay. So, for example,
Or data.
A biobank that gets a broad consent, but and the consent form.
Yeah.
It's an example from a
Yeah.
biobank. It doesn't mention about this.
Yeah. And this is true.
So
Yeah.
This is,
So you're going to have to share data outside of the consent that's been provided, and this is something that we've raised. So we have very clear. We've I think 4 conditions or 4 broad areas of research in CRIS where we have said that we're going to get access or use their data for. But we may now, and we're a basic research biobank, so we can't even share data for applied research. But we may now get an application. We could, in theory, be obliged to share data beyond the consent, and what that impact that's going to have on our very strong relationship with our participants, it remains to be seen. I think you want me to stop, do you?
no,
Okay.
I have one more thing to say.
Yeah.
In regards to human rights, the right to privacy.
Yeah.
I think this is there is a conflict there.
It does consider data protection.
This catalog.
So it does consider data protection, and what I don't like about the European Health Data Space, well, there's many things I don't like, but one of the things I don't like with the European Health Data Space is that it kind of makes this implicit assumption that re-identification and data protection are the only concerns in the reuse of data, when they're a concern, but there are many, many other concerns. I just don't, we all have personal decisions and preferences in how our data to be used, and the current system and proposal is not going to change that. if we adopted a more dynamic infrastructure, and the thing is, the Commission is at a time when it's going to change, things need to change, that we know, and has a real opportunity to change it in a good way. But it's kind of like a lazy approach, just to it. It's not really thinking about how can we change. They're building infrastructures, so why not have an infrastructure where we can kind of select and choose and update. Now, we as the subjects of using our data will have responsibilities, of course, in that system. We will, if they had a more dynamic infrastructure, responsibility to keep our information up to date so that we would actually engage with the system. But if they're going to do it, then do it right now rather than, because this is a system where we're going to be stuck with for the foreseeable future.